No, that's, and again, if you were studying law, you would study this, and you would kind of, you'd have to understand what that meant. All right, so what we're saying is your right to an attorney extends to the interrogation phase, or the investigatory phase, not just the trial itself. Gideon versus Wainwright comes next. Do you recognize?
Yes.
Okay, so what am I doing with the right to an attorney there? Who's Gideon?
Oh, he was an impoverished person. Who was
Right, there you go. So if you can't afford, so essentially what I'm saying is the right to an attorney extends to you even if you are poor, right? It comes to you at whose expense? State's expense,
you
right?
have a right to an attorney.
An attorney, and that's an important kind of thing, I suppose, to kind of distinguish, because we often think legal representation on some level is equal, but there's different calibrations of law firms that have different levels of experience and success rates, and they charge different amounts. So essentially what you're gonna get here is a public defender. And it doesn't mean that they're not skilled and talented. You get a lot of good people that go into public defense for altruistic reasons, but you're gonna get maybe someone that is really overworked in part, with a massive kind of caseload, maybe with not the same resources as that high-end law firm that maybe people can afford different levels of justice. But on the bottom line, you are gonna get an attorney here.
Right. Do you think, because this is what you think of it, when we have some time, there's an audio recording for Sanchez versus the state of Georgia, and it was basically it was the show Rick and Morty, the voice actors acted out a,
Were they actually reading over
that? They actually read
that?
off a real transcript of what happens when a
I don't have that, but I will, you'll get to hear some of the great words by the Supreme Court, but there's a more entertaining way to kind of hear their oral arguments, and I'll say it's next unit. So you'll get to kind of see a dramatization of their words, not by Rick and Morty, but by something almost as equally entertaining.
Nice.
All right, so with Gideon versus Wainwright, again, you guys have got the details. Essentially what you have is, he was indigent, meaning impoverished. He breaks into a pool hall. He's charged with breaking and entering. He doesn't necessarily able to afford counsel, and the question is, can you cry poor as a way of not, in the case of the state, and not give somebody their rights? If they can't afford their right on their own, is it the burden on the state to provide it for them? And they decide, in fact, yes. In Betts versus Brady, that overturned Betts versus Brady, we will apply this to the states. This is again also an incorporation case. Miranda.
Yeah.
All right, so what am I doing there?
Putting it all together.
Kind of, yeah. Right? I'm making sure that all of these things that you just mentioned are what?
Federally applied.
Not necessarily federally, but told, right?
The 14th Amendment.
That your rights are so important that you have a right to know those rights, and that the state has to actively inform you of those rights. So that's what I'm saying. If you say, hey, can I come in? And they say yes, okay. But if I am starting to move towards an arrest as a result, the police have to go through those pains of like, before you say anything, do you know your rights? Do you know what you're allowed? And so there come the Miranda rights. That's where law and order helps you, right? You can kind of almost do it verbatim. How far can you go?
Right to remain silent. Anything that you can use against you in the court of law. You have a right to attorney if you cannot afford one will cry for you. And then.
Do you understand these rights? It's not good,
Yeah.
right? So how does this case come about? Well, again, I've got a guy that's he's a little mentally off. We're going to use a 2-hour investigation where there's some deception being used about how they have corroborating witnesses when they don't necessarily, and they've got this positive ID. And essentially what they were arguing is that this guy there were deceitful tactics. They used his psychosis against him and really kind of took advantage of where he was mentally, and they didn't do the job of informing him of his rights. And so, again, not only are we going to uphold these Fifth Amendment rights and say that you can't do an interrogation-based confession where you haven't taken the pains to inform them of their rights, but this will apply to the states as well. And so again, for Charlie, there's some great lines up here. No statement may be used when it stems from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privileges against self-incrimination. You can't use it unless you've done these procedural safeguards, and the procedural safeguards are what you guys just kind of, were able to quote verbatim. They'll carry it on a card, they have it in Braille, they'll do it in Spanish if they need to, if they gotta bring in an interpreter, they're gonna make sure that you know your rights. Now, what happens if you spontaneously confess and someone hasn't given you your rights? Is that a way to get away with a crime?
No.
Right? They're about to say, you have the right, and you go, I did it, right? And then you say, you didn't read me my rights, right?
Nice try.
Yes, spontaneous confessions are not inadmissible. You might backtrack, you might go through and say, okay, now hold on, do you understand what you just did? Do you understand your rights? But that's still admissible, that person spontaneously confessed, and then you leave it up to the jury. Again, this will be another one applied to the states.
Did Miranda actually do it? Or did they ever find out?
Again, essentially and I'm trying to think if there was any, was this a case of overturned an appeal? I don't think there was. What's funny is you get locked in on the standard and you kind of lose track of the individual.
Right. I'm gonna look it up. I'm gonna see what
Yeah, I don't totally have an answer for you, and essentially what they were saying is the police, the larger issue wasn't necessarily the guilt or innocence, it was the police tactics.
Right.
And that becomes the focus of the case. So, again, you guys kind of know these rights, as does everybody, right?
Collin was forced to drop the charges because you forgot to read him his Miranda rights. What possible reason is there for not doing the only thing you have to do when arresting someone?
I did read him his right. I did a version of that.
Do you even know the Miranda rights?
Yes.
Let's hear him then.
You got a lot of stuff to do. Go ahead.
You going anywhere, Schmidt? You got time?
I had a thing that I could probably push it back.
Go ahead. It's 4 declamatory sentences followed by a question for a total of 57 words.
Okay. Look, it obviously starts with you have the right to remain silent. I know you've heard this before. And then I think it sounds something like right. You have the right to remain an attorney.
Did you say that you have the right to be an attorney?
You do have the right to be an attorney if you want to.
That guy from Superbad.
And that's true, that is the guy from Superbad, and it is true, you do have a right to be an attorney. I just like the idea that it's like 4 declamatory sentences followed by a question, 57 words. How universal is it? Now, all of that is straightforward. Here's where it gets a little tricky. Because we're about to look at where privacy is, the right to privacy. Do you universally feel like you have a right to privacy? It starts as a kid, right? You start to argue with your parents as to whether your bedroom is your private domain, whether they have to knock before they come in, right? Privacy is something that we feel almost on the primal level, because that's security, I suppose, right? The right to be secure in your home and your possessions. But is it in the Constitution? It's one of those fundamental rights, but is there actual language about privacy? So we're gonna have to look around corners to find it, and the logic as to how they arrive at it is kind of fun. And once they find it, does it open up a range of what's included?
So
What happens
what happened
with
to Miranda? So
Yeah.
Miranda went to jail
Yep.
in '67. He was sentenced to 20 to 30 years, and then he was allowed parole.
Okay.
And he went, 20 to 30.
2230, I heard 230. Kidnapping charges?
So he returns back to his regular home,
Yep.
and he actually makes a living autographing the Miranda cards for local police
fine.
officers.
Yeah.
And then
Celebrity.
And then 1976, he walks into a bar and is stabbed to death.
I knew that part. I forgot
and
about
then
that.
And then the suspect used his right to remain silent, which he had just gotten through this case.
There's a little Shakespearean kind of poetry,
And
right?
then he was released with no evidence because there was no evidence against him.
Yeah.
So we know evidence when you stab a man in the ribs, but
Yeah, so again, what's interesting is half the time that is almost more interesting than, it's not more interesting than the right itself, but what we focus on is that, and we forget. Like, Columbus comes to America, and then we forget, oh yeah, he was sent home in chains. And kind of disgraced, because that's the point that we wanted to make.
I think the weirdest
So good.
part of that case, though, is that they kind of determined that it's not okay to not inform him of his rights, but then he's still convicted.
Still convicted.
It still goes
Right.
forward.
So,
then, so then does it really mean what it? Yeah.
again, if the police relied on that solely, then that's not a system of criminal investigation, that's a lynch mob,
Yeah.
right? So what you can assume from that is
There had to be some
they had to go back
evidence.
and rely on some other things,
So
other than the confession.
Yeah, here's what they actually did, so instead of relying on his confession, they actually, because they didn't want to use that bit of evidence, but there was a witness named Twila Hoffman.
Okay.
Who came in, and she said, that after he committed the crime, he confessed to her, and
Gotcha.
then she reported it, and
Right.
they used that against him.
And they may have had forensic evidence and other kinds of
Yeah.
things like
So
that.
they threw away a piece of the evidence, but they were still charging him.
Charging
Yep.
him because they had enough.
That makes
evidence.
sense, good. All right, let me set up privacy then, so that you guys can kind of understand, A, how we find it, and B, the implications. So, again, where does the right to privacy come from? Well, again, what's the ninth? It's one of the more important ones.
All powers not with the federal government
No.
are with the people.
That's 10th. That's 10th. Your right idea, we're just gonna apply that concept where? What's the ninth?
People?
People.
People.
I said,
Didn't he say people?
I said,
Yeah,
You said states.
so I said the federal government to the people.
yeah, he did.
Oh, say it again, how you said it.
I said, all power is not reserved by the federal
Okay,
government.
because you're using reserved, that's why.
Oh.
So,
Reserved.
again, there's delegated powers to the
All power is
federal
not
government.
delegated to the federal government.
And once you
Oh,
start
we just
saying,
got cheated.
once you start saying delegated and reserved, that's the 10th. That's states. Wrong kind of concept. It's essentially, again, the idea that if I'm writing down rights, is there a fear that it's gonna be finite, right? So use this language, any unenumerated rights
Are left to the people.
are left to the people. So you need the idea of unenumerated rights. Rights that aren't written down, that are still rights, are ours.
Okay.
So you might be able to find it in the ninth. And again, it's gonna be in other locations. So for example, Fourth Amendment. You have a right of protection against illegal searches and seizures, right? Is that privacy? How about the the Third Amendment?
Quarter.
Is that privacy? Right? Right of association in the first? Like, you're gonna stack a bunch of these up and kind of like, if you look at it the right way, say, well, that could be privacy. You have kind of unenumerated rights are still yours, and these other rights collectively kind of suggest it. And if there is a right to privacy, is it just privacy in terms of your home and your documents, your possessions? Or can it begin to include medical and physical choices that you make, right? This will be the right that is used to guarantee a woman's right to abortion. And once we start to think that people have a right to make medical decisions, does that extend to other kinds of choices? Drug use, prostitution, physician-assisted suicide, or euthanasia, or that kind of stuff? Literally, you open up this kind of Pandora's box with it. It all starts with Griswold versus Connecticut.
Oh, we went over that one last time.
Yeah,
Yeah.
so you remember this one? So essentially what we're looking at is simply the idea of providing birth control counseling. There's a clinic in Connecticut, and they provide and furnish birth control information. Now notice it's 1965, and this runs against a statute that says that that is a violation of the law, that any counseling and giving a medical treatment to married purposes for the purposes of preventing conception is illegal. The idea is, again, this kind of Judeo-Christian Catholic kind of sensibility that procreation is for children and it's God's will, and any kind of again, I'm on tape, but any kind of if it's not for procreation of children, don't do it. And contraception is violation of kind of God's will in a sense. I mean, that's literally where we're at. But what the court is deciding is, no, wait a minute. And again, Charlie, you'll love this behavior, because now it's the court talking about uncomfortable things. But the behavior of married people in their bedroom is protected by the right to privacy. Where do they find it? Literally, they say in the penumbras and emanations of the amendments. Now, a penumbra is where there's this like partial eclipse and there's a shadow. It literally means a shadow of shadow. Right? We're finding it in the gray areas. An emanation is something that kind of is this intangible, unseen thing that radiates from a source. So when you look at the kind of the overlap of the amendments and you look in kind of the corners, that's where I'm going to find it. This is literally the language of the courts, penumbras and emanations. Again, the government is not supposed to be involved in the behavior of married people, and these are the two that win the case. This is where we find them. First, rights of association. Third, quartering of troops. Fourth, eminent domain. Cruel and unusual punishment. That's you have a right to kind of control your body, I suppose. The implied rights and due process rights. Put those all together, and you get the right to privacy, and then we're going to apply it in Roe v. Wade. I got maybe 5-10 minutes left, and we'll wrap
Yeah,
up with
we have
this
two cases.
tomorrow. We're going to watch our movie tomorrow.
Cool. Oh, we have
I
one.
never thought of that until this moment.
Wait, what?
What's that?
No, I'm just,